day to you all students. So today I'm going to discuss regard to the formation of partnership. Okay. So as we know that a partnership is to be entered on voluntary basis. So meaning all the partners, they consented to form the said partnership. So under this situation, it can be formed either with an agreement or without an agreement. However, if there is no agreement, so how are we going to determine the rights and also the duties of the partners? Because it is not settled anywhere. So under that situation, if there is no agreement, what we can do is that we can look at the Partnership Act. So the provision of the Partnership Act will comes in when there is no written agreement. However, if there is a written agreement, of course, we are going to give priority to this written agreement. Okay, so I've stated here, there is no provision in the Partnership Act. So meaning nowhere is stated inside the Partnership Act. Then to enable a partnership business to be valid, they must have an agreement. Okay, so that's why I say there is nowhere stated in the Partnership Act or any other statute, meaning in any other law, saying that a partnership agreement must be in writing. So, however, if let's say there is a written agreement, of course it is an advantage to the said business. Why I say it's an advantage to the said business? Because if there is a dispute, if there is a misunderstanding later on, which occur between the partners, they can always actually refer to the said agreement. However, if there is no agreement, as I informed you earlier, the provision of the Partnership Act will actually comes in. Okay, so the partnership agreement, sometimes they did not call it as the partnership agreement. It can be known as some other form, maybe article law of partnership. And then we have a look at the case of Rana Amma. Okay, the partnership agreement is said to be a syndicate. They wanted to form a syndicate. However, what did the court hold? The court held actually this is actually a partnership business. Okay, so if there is a partnership agreement, most of the time, what is actually the contents of the said agreement? So most of the times, this will be the main contents of the agreement. So I'm not saying that this is the only content which should actually occur in the said agreement. There can be any other extra contents. However, this is the main one. So what is this? The parties to the agreement, the nature and place of the business. Of course, we wanted to know who are actually the partners and where actually the place of business of the said partnership. What is the firm name, the name of the partnership, the duration of the partnership. Okay, so the provision of capital. So this is good actually. If there is provision of capital, then if there is dispute, we know actually each partner contribute actually how much towards the said capital. The division of capital and profits, the settlement of partnership property, the management of the business, methods of dissolving, the change in the firm and the right to expand, and restrictions on a partner, whether they can open up a new business which compete with the said partnership. So if it is being stated inside the agreement, of course, it will be much more clearer and it will be much more easier. If there is a dispute between the partners later on, in future, they can just refer to the said agreement. So now let us go on with the types of partnership. So these are actually the three types of partnership. Quasi-partner. So what is actually a quasi-partner? A quasi-partner is a type of partners who actually, he is not a partner, however, because he has holds out to the outsiders, okay, that he is a partner, meaning he show off. He show off to the outsiders, maybe through his conduct, maybe through his words, that he is a partner. Then under that situation, he will be liable as a partner to the said business. Okay, however, he is not entitled to the profit. Why? Because actually, the real situation, actually, he is not a partner. However, just because he have show off to the world that actually he is a partner and the outsiders is not aware, actually he is not a partner, and they presume actually he is a partner, then he will be liable. He will be liable to the said partnership business. Then we have the active partners. This is normal partners, whereby these partners participate in the business, he manage the business, he make decisions together with all the other partners. Okay, so this is known as the active partners. Then we have dormant partners or sleeping partners. This dormant partner or sleeping partners, actually, he is the partner of the partnership. However, he does not act actively in the partnership. He receives profit, of course, and at the same time, he will be liable towards loss towards the partnership. Okay. However, he did not control the business. He did not manage the business. He did not know what is going on with the business. So that's why we call him as a sleeping partner. Okay. So actually, who can become partners? Okay. If you wanted to form a partnership, you wanted somebody to become your partners, can he actually become your partners? So if we go back to the law of contract, which have been taught to you last semester, under the law of contract, who actually have the capacity to enter to the contract? If according to the Age of Majority Act, a person must be of 18 years old, okay, before he can be eligible to enter into a contract, okay. So this is very clear under the Age of Majority Act, and under Section 11 of the Contract Act also state that a person must be of full age, he must be of sound mind, and he is not being disqualified, okay, from any law, okay, for entering into a contract. So, does it mean that a minor cannot become a partner? Does it mean that a person of unsound mind cannot become partners? Okay. So, of course, a contract which is being entered by a minor, the minor will not be liable towards the said contract. However, inside the Partnership Act, actually, there is no restriction saying that a minor cannot become a partner. It's just that if a minor becomes a partner to a said business, he will not be liable towards whatever liability of the firm. So meaning the supplier cannot sue him. He can sue the rest of the partners, but not him, because he is a minor. So actually, they can form a partnership between a minor and also a person who is of age of majority. However, the risk is that the other partner who is of the age of majority, he is the one who will be liable, meaning the risk, he need to bear the risk alone. Okay. So we will look at the case of later on, the case which involves a minor, and in the case of Goetz versus Harrison, it has been established that a minor could be in a partnership for any duration of time until he himself wanted to disaffirm it. So meaning, okay, maybe after he reached the age of majority, he don't want to become a partner, he resigned, and after that, of course, he will not be liable. So in Lowell versus Christmas versus Beauchamp, it may say that minor has the capacity to enter into a partnership agreement, have capacity to become a partner. This is what the case meant. But he cannot be personally liable to be sued or responsible for any contractual liability for the firm's debts. So meaning the supplier to the firm cannot sue him. And on reaching of the age of majority, he may discharge himself from all future debts of the firm by terminating the partnership agreement. Because if he continues, of course, the future debts, he will be liable. Why he will be liable? Because at the time he had already reached the age of majority. Okay? Okay, this is a Malaysian case. We have done this case when we were doing this law of agency under implied agency. So this case involved William Jackson Company versus Chan and Yong Trading. So actually this Yong, he is a minor. However, Chan have introduced him to the supplier saying that this is his partner. Okay? And later on, this minor, Yong, he ordered goods and good was supplied and did not pay for the goods. And because of that, what the supplier did now, the supplier of course sued the other partners who had already reached the age of majority. So can he deny liability? Cannot, because why? Because I've informed you earlier in section 7 actually, partners they are each other agent. And because of that, partners will be liable towards whatever doing of the other partners. So under this situation, Chan, who is actually the person who have already reached the age of majority, he will be liable towards the said debts. Okay? Okay. So, if let's say their business is an illegal business, okay? So is this a valid partnership? No. So an illegal business, if a partnership is being formed to carry on a business which is illegal, then actually the partnership is actually void ab initio. So, of course, if the commercial purpose is illegal, what is illegal? So let's say this is a trade with regards to drugs or ketum, So this is something which is illegal. Then under the situations, then the partnership will become a void ab initio. Okay, it's not a valid partnership. It will be void from the beginning. Okay, sometimes the partnership is being formed to carry on a lawful business in an illegal manner. Okay, so let's say this business is a legal business. However, it does not obtain a certain license, a certain permit to be operated. Then under the situations, this kind of business is being carried in an illegal manner. Okay, especially those business involving gaming and perjudian. All these they need to obtain certain license. Okay, and law also prohibits partnership between certain people. So if the partnership is being formed more than 20%, and this is not professional, they are not professional. We said that professional are engineers. This is an example of professional, lawyers, accountants. Okay, because they have certain certificate which recognize that they are actually professional. So if this is the situation, then the partnership will become void. In the case of Tak Technique or Secheng Champeng, whereby this business comprised of 25 members, and the court held this is not a valid partnership. So meaning now, they have to form a company because there are more than 20 members. So what about registration? Because I informed you earlier, a partnership, they need to register under the Registration of Business Act. Okay? So in the case of Gulazam versus Nur Zaman and Sobat, what happened in this case? They failed to actually register the said business. However, the court held this does not affect the right of the other partners to claim indemnity towards the rest of the partners. So if their partnership is not registered and they carry on business, okay, and let's say if the supplier is one of the partners can actually claim indemnity from the other partners. So meaning he can sue the other partners to be indemnified for compensation. So okay, students, that is under this topic. Okay, so please go back and do your revision. With regards to this topic, go back and do your revision. So until I see you again next week on the other topic. Thank you, students. Bye-bye.